Swayam Prabha. Digital India. Educated India.
Sir, you are live now. You can start your session.
Good afternoon, everyone. Welcome to the learners who have joined our NPTEL course titled Medical Law. As you know, we have proposed our medical law for 8 weeks. So right now it's a week 4, which is online. So we have covered till date is the first 3 weeks. Week 1 was on the introduction of medical law and regarding their duties, rights, and between the medical professionals and the law professionals. And then we have discussed about the week 2 about the types of concern, the various concerned related legal issues coming in during the routine medical practice, and the ethics involved in the clinical practice. What are the do's and don'ts of the doctors, medical professionals, and the legal professionals? And then we have moved on the week 3. We discussed about the medical negligence. What about the various types or the vocabularies like res ipsa loquitur or various types of medical negligence? Very famous, the medical judgments coming on the medical negligence, about the Bolam test, Bolam principle, and how the doctor should, like whenever the medical negligence happen, how the doctor or the clinician practitioner can defend himself while undergoing the any procedure or the treatment during routine practices. So we have discussed many interfaces between the legal and the medical, which is not much explored nowadays. So it is very much was necessary to come up with this course, which I have explained about both together. Whatever being the scenario, it's have linkage between the medical and the law background. And later on in the further course, about the we will go through the week 4 about the clinical establishments and the healthcare sectors. Then further weeks, week 5, week 6, week 7, week 8, we will you can go through the various other topics related to our course medical law. Week 5 will be on IPR, intellectual property rights. Then week 6 will be on the interlinkage between the medical jurisprudence and the forensic science. What all are the duties of the doctors while taking the samples in case of any medical legal cases coming to the routine practice in the casualty, or how to collect and preserve the samples, where to send it properly, and how to maintain the chain of custody. These all you can go through in the week 6. Later on, you will see study about in the week 7 about the surrogacy and assisted reproductive techniques legal regulations, which will be on the famous famous judgments or the new laws coming up with the surrogacy, who is being the eligible to undergo the surrogacy. Especially the doubt has come up on the OCI, like the overseas citizen of India, or the PIOs who are actual the Indian origin but are not staying in India, they are the foreign nationals. So it is very much clear cut that only one citizenship should be there. So the people who are the OCI, having the OCI, so they have to take the permission from FRRO, that is a foreigners regional registration officers, that whether they are eligible to undergo the procedure of surrogacy. So many all these things you will go through under the week 7. And the last week 8, we will cover the various other topics on related to the organ transplantation. What are the ethical and legal issues the doctors are facing during organ transplantation, law governing during the organ transplantation and organ donation, medical legal issues in the various clinical trials, and the regulatory law for the clinical trials in India. So like this, you will go through in the whole course in the medical law about the various subtopics in which the medical and the law interface is very much necessary to understand, and how to face all the issues related to it. So this was all about the overview of our course. If the any doubts which the learners have faced, they have posed it over on the discussion forum, on the live, who are there on the live session, they can post their questions on our YouTube link chat box so that we can answer you whatever the doubts you have. Thank you from my side. Now, my the co-faculty will say something.
Hello everyone, I'm Dr. Narendran. I teach intellectual property law in IIT Kanpur. So we have crafted this course in a multidisciplinary manner. So by this time, I hope you might have understood that this is not only from a single point of view, but we have combined both the medical field as well as the legal field, and we are actually looking at the intersect between these two fields. So this course, the learners, we understand that are from different backgrounds. So some are from the medical profession, some are lawyers, some are law students. So because of that, we need to cater to the requirements of these diverse participants. So accordingly, we have crafted the course in a very simple manner. So it started with an introduction to medical profession and law. So where we have already given you the basics of the course and also introduced you to the ethical concepts related to the medical profession. Subsequently, we have taken you through the legal concepts like the consent, for example, which is a concept which is internationally accepted. So, and subsequently, we were taken to the issues like medical negligence and medical malpractice, which is also very controversial with regard to medical profession. So then we have also introduced you to different case laws, which I hope you all enjoyed, understanding the case laws and the recent developments in India and at the international level. So now almost 4 weeks of the course has been completed. So that means half of the course is already done. So I hope at least the basic things you were able to understand in a good manner. In the coming up weeks, we will be taking you through the advanced areas related to medical profession and the public health and intellectual property rights, where the advanced issues will be discussed in detail. So now please use this opportunity to ask questions. So we are here to clear all your doubts. And we also received some questions through the chat option in the NPTEL portal. So that also we'll be taking up now. So let us start with some questions that have come through the chat box.
Yes. So the question was asked like, can a hospital refuse? Yes. So during the week 1, it was asked like, what is the difference between the DNA sample and the DNA profiling? So it's very easy to understand. Sample means it's like a like tissue or any body fluid or any blood or whatever the tissue or anything seen in a crime scene or the scene of incident. So in like touch DNA or the fingerprint or the footprints. So anything, whatever being the suspect or accused has left over the scene of crime. So that has been recovered by the forensic science expert, so to retrieve the DNA. So that will be considered as DNA sample. But the retrieval of the DNA, so that will be considered as DNA profiling. That is a forensic method in which the DNA samples are examined to identify the people and compare it whether really that accused or that person was there on the scene of crime. So this was a question being asked in the discussion forum for the week 1. What is the difference between DNA sample and DNA profiling? Simple. Sample means just a tissue or any fluid, and profiling means the process, how to retrieve the DNA and the match. And then regarding the further being asked is what do we mean by the brain mapping test? So it is very much simple to understand. It's like to find out what are the changes are coming up in the electroencephalogram while asking or questioning the suspect or the accused whether he is saying truth or the lie. So that we have to record it. So how we record? While using the electrodes, put it over on the skin of the head and the face of the particular suspect, and look over the electrical field potential to see the neural activity in the brain. So what all the changes come up? So different types of question being asked. Some are asked really based on the personal profile, and then what happened during scene of incident. So if person is saying lie, then the changes will happen in the electrical changes will happen, and that will be documented. So like this, you can able to identify that whether the suspect was present or not during the scene of incident. So if even he is present, then also few changes will be there. Or and if he has done that crime and he's saying lie, then also changes will be there. So like that, this brain mapping test can be helpful. But definitely, it's not an 100% proof that, but it helps a lot during a law or during a trials. So it helps as a corroborative evidence in a court of law. So it's very much helpful, like other like detector test, polygraph test, brain mapping test. So this was the second question being asked by the learner. And another question which was asked regarding on the week 2 and week 3 is on the vicarious liability. So the question was, in a large hospital having several departments, what vicarious liability lies with the administrator for a case of negligence? Under what circumstances the law of vicarious liability is not applicable? So you have to understand the term vicarious liability. It clearly means that whether the like whatever the servant does so is employed under master. So master is responsible for the act done by the servant. But when it is not applicable, so that means if servant has done very like gross mistake, or in a terms of legal criminal negligence, or the damage that even layman cannot do that. So okay, the act done, very wrongful act done by the servant, in that case the employer or the master will not be responsible, will not be vicariously liable of the particular servant. Second, also, if the servant is not on that duty or not under that master, somewhere else, so if off duty from the master duty place and went somewhere else, so whatever the servant does so in another place, in a new place, whatever the act, so he only will be, or the servant will be only responsible for the act done. So in that case, the employer will not be held responsible or will not be vicariously liable on the act done or the wrongful act done by the servant. So this was on the vicariously liability, the question being asked. Another question was asked on the what all the cases come on the broad dead cases or the dead on arrival in hospital. So the question was asked like, what medical legal provision exists for a case declared broad dead or dead on arrival in a hospital? So you have to understand that whatever the case scenario, if it is in suspicion, foul play, doubtful, now broad dead or dead on arrival, so we can't ask anything from a patient. Patient is either unconscious, declared dead on arrival, broad dead, whatever being the scenario. Okay, we can't ask anything what has actually happened to the patient. So we have to, we means the doctor, who is a treating doctor, has to label that particular case as medical legal case. So once we label it, that broad dead case, once we label it, it's mandatory duty of the treating doctor to inform to the concerned police station, mentioning that this is a broad dead case has come up, or even one or twice CPR has also been given and doesn't revive the patient. So it's considered to be as a broad dead case. So it's mandatory duty to inform to the police that such case has come up. Then on arrival of police, the following procedure being started regarding postmortem examination has to be done or not, or how we should proceed it. Then it's a take of legal authorities or the legal agencies, what decision being taken. If the doctor says that the cause of death is such so, okay, the cause of death is clear. Secondly, the investigation agencies feel that there is no doubt or no foul play. Okay, then combining these both, the cause of death and no foul play, the waive off the postmortem examination can be done by, but all complete right goes to the investigation agencies. So by the treating doctor, it's mandatory that inform to the police and shift the body to either mortuary, okay, for further postmortem examination. Then there, with the help of forensic medicine expert, the investigation agencies and the treating doctor all combined opinion that cause of death is clear, no foul play, and relatives want that they doesn't want to conduct postmortem examination, then only the postmortem examination can be waived off. If nothing being clear, cause of death is not clear, if there can be a doubt of suspicion or foul play, relatives, anyone goes for an postmortem examination, definitely the treating doctor has to shift the body to the mortuary for postmortem examination. Investigation agencies will do the inquest report, panchnama, and further formalities to undergo the postmortem examination. So it's very much mandatory in the broad dead cases, is very much clear cut. Whenever the such broad dead case comes, has to be labeled as a medical legal case. And the waiving of the postmortem examination has completely power only with the investigation agencies, nothing else. And one more question being asked regarding the homeopathic doctors or the Ayurvedic doctors, or you can say Ayush doctors. So as you know, our concerned law is on the medical law. Mostly we focused on the allopathic doctors and the legal practitioners there. But what I think, it's all completely the practice part. Whatever being the degree, either the MBBS, BHMS, BAMS, Ayush, Ayurvedic, any word. So main safe and the regular routine practice is a foremost thing is documentation. So if you document it properly, whatever way, the date and time, your procedure, then the consent part. Okay, if it is everything is properly documented, you have maintained your medical records properly and retained it whenever being required, you have provided to the investigation agencies. So these all are the laws are applicable for each and every person. But just the council can change. Medical Council of India, now National Medical Commission, who has made the laws and regulations for the allopathic doctors. Like that, Ayurvedic has their own council, or homeopathic doctors have their own council. So the foremost and importance is the documentation and to the safe clinical and medical practice. So these were all the discussion forum, the question being asked by the various learners, audience who were there. So, and there are the further questions are also there. My co-faculty will take.
So there are some more questions that has come in the discussion forum. So I'll address some questions now. So one question that is asked is related to the medical records of a deceased patient. So is it mandatory to give the records of a deceased patient to whoever who is asking regarding for the documents? So one example is if a legal authority is asking for the document, they are empowered to ask for the documents. Under the relevant provisions of the Code of Criminal Procedure and Indian Penal Code, they can ask for different documents, which has to be given, which is mandatorily the hospital has to give such information. But apart from that, they have to give the relevant information to next of kin also. So if the patient is deceased, then the son, daughter, or parent of the patient is asking for the documents, then the hospital or the doctor have a legal responsibility to give the relevant information. So that is mandatory. But apart from these persons, the hospital or the doctor also have the responsibility to keep this information as confidential, because it is related to the privacy of the patient. So this information related to the disease or the medical condition of the patient is also related to the privacy. So because of the requirement of ensuring privacy, this information cannot be divulged to anyone else, apart from these legal authorities to whom the document has to be given. The second question is regarding what is the liability of a duty doctor in case of a sentinel event in hospital. So we have already discussed in detail regarding the responsibility of doctors and hospitals. But in case of an unexpected event or a sudden event which is happening, then in such cases, the doctor has only very limited responsibility. Only thing, we have to ensure that there is no criminal negligence on the part of the medical professional. So apart from that, there is no other responsibility. But as a hospital establishment, they would have responsibilities under different applicable laws. But there won't be any criminal negligence allegation against the doctor, because it is not the doctor's responsibility. The third question is beneficence, can it be equated with benefit? So these are actually completely different words. Beneficence as a principle is related to medical ethics. It emphasizes the obligation of healthcare professionals to act in the best interest of the patients. But benefit is a completely different word. Now, another question that has come in the chat box is related to the written consent. So it is being asked whether there is any specific format or standard format for taking consent. So there is no standard consent format prescribed under the law, but the hospitals establishment have their own format which have to be followed by the doctors while taking the consent. It is always advisable to have a standard form in which the consent can be taken, but we have to ensure that all the relevant information has to be properly entered in the consent form. So, for example, the proper details of the patient, including the time and date of admission, the information of the patient like the name, age, signature of the patient, or if the consent is being given by the nearest relative, then the information of such near relative also has to be mentioned, and the name of the doctor, designation, all these things also has to be mentioned, and witness signature with the name of the witness and the signature of the witness also has to be given properly in the consent form. And the other information related like the disease the which is identified, the surgical procedure which is planned to be followed, all these things also has to be properly mentioned in the consent form. So there is no statutorily prescribed consent form, but the hospitals have evolved their own format in which the consent have to be taken. So another question is related to the applicability of the PN Thakur versus Hans Charitable Hospital judgment. So the responsibility of a doctor when he's making a referral, we have already discussed in detail during the lecture. But we have to understand that the doctors have to take adequate care while prescribing any medicine to the patient or doing a referral. So this principle which the Supreme Court has laid down in the case has to be properly followed. So now there is another question, whether the electronic record has to be maintained. So manually, hospitals have a practice of maintaining manual records. But apart from that, whether electronic record also need to be followed, or is it mandatory to maintain in both the formats? Such a question has been asked. So under the law, the maintenance of medical records is mandatory, but the format is not prescribed. So it is up to the hospitals whether to follow electronic format or the manual format. So, but the most important thing is the integrity of the document, the authenticity of the information has to be ensured. That is what is important. So many hospitals we know will be following the manual format, but some of them have now is undergoing the transformation to change it into electronic format. So electronic format has its own advantages because especially in case of voluminous data, it is better to have electronic format. Another question that is asked is whether there is any standardized format for case sheets for maintaining patient records. So I request Professor Mittal to answer.
Yes. So this was a question being asked that whether there is any format of case sheet in medical records. Similarly, the question was on the format for the consent. So actual and legally, we can say there is no standardized format for even consent or the case sheet how to be made. It's all can be made by their own formats of the various corporate hospitals, by the various private hospitals, or even the government hospitals. But the main thing is that all the details to be mentioned properly in that particular case sheet. The documentation of each and every step should be there in the case sheet, should be documented properly with a good handwriting. So now as many have asked about the electronic as well as the manual records. So all these things have the pros and cons. Electronic, so it's a good handwriting because it's a typed one, can be saved voluminous records in a short and small space, but there can be a deletion of or the technical error. So we have to timely storage to be done or safely stored at different place. And manually, that can be torn, tear, or even fire can be there. So we can lose the manual records. So like this, main important thing is the genuinity of the documentation of that particular case sheet or the consent. So like this, there is no specifically standardized format is there, but main thing is the documentation case of any patient who is admitted in that hospital. Thank you.
Okay, now we can answer some questions which has come through the chat box in the YouTube link. So one question is, in which condition can a doctor refuse a treatment to a patient? So the general rule is that the treatment to a patient shall not be refused, because doctors have an obligation, medical establishment also has an obligation to take care of the patient in the time of if there is an immediate need of care. So doctors generally cannot refuse to treat any patient. But there is something that the National Medical Commission, the country's medical education regulator, has said in the professional conduct regulation that in some exceptional cases, doctors can refuse to treat the patient. It is in case of abusive, unruly, and violent patients or relatives. The registered medical practitioner can document and report the behavior and refuse to treat the patient. And NMC guidelines also says that such patients should be referred for further treatment elsewhere. So in such exceptional situation where the patient is abusive, unruly, or violent, in such cases alone, the medical professionals can refuse to treat the patient. But at the same time, they have an obligation to take care of the patient. So if there is some need of immediate medical attention, then it cannot be denied. And secondly, in case he is refusing to treat the patient, then they have to be referred to appropriate place for the further treatment. Then another question is, in what situation is sharing of information with the patient harmful to the patient? So generally, doctors have an obligation to keep confidentiality with regard to all the information they have received from the patient. So whatever the doctor has learned from the patient, especially information which is secret in nature, which is related to the privacy of the patient, cannot be divulged to anyone. So doctors have this obligation to keep the information as confidential and shall not be shared with anyone else. But if it is related to diagnosis of a disease, then of course to the near relatives, it can be informed, especially if the consent of the near relatives has to be taken.
Also, that if the doctor want to reveal the particular diagnosis, for an example, the cancer, if doctor has found out any life-threatening disease, then definitely have to inform to the patient and the relatives, but with a counseling. So there should be a soft release of the diagnosis. So it should not that, oh, this has happened to you. Okay, there should be a proper counseling. There should be a way how to reveal that particular bad news. So that is a revealing the bad news to even patient himself or herself and to the near relatives. We can call, like if it is being informed to any female, so we can call the spouse. Okay, you both can come together, counsel it. Okay, so this is a situation. So but suddenly informing, it's very much harmful to the patient and even to the relatives. So we have to reveal the bad news with a pace and a counseling manner.
Also, in case of infectious diseases, it has to be informed to the public authority.
Please.
Then another question that has come is, there is a right of doctors to decide whom to treat as per NMC laws. Can you please explain this principle in detail? So according to the Code of Medical Ethics Regulations, doctors are free to choose whom they will treat. However, the National Medical Commission has also released the guidelines for the professional conduct of registered doctors. So as per the guideline, doctor can refuse the treatment only in very exceptional circumstances. So one is the treatment can be refused if the patient or the family members are abusive or unruly or violent. It can also be refused if the patient cannot pay. But doctor should not neglect the patient or withdraw from the case without giving adequate notice. That is also very important. And doctor should prescribe generic medicine except in cases where a small dosage difference could lead to adverse outcomes. So it is important that the doctors should take care of the interest of the patient. But in some exceptional cases, the treatment can be refused. But then the interest of the patient has to be taken care. So he has to be referred to an appropriate place. Also, if the patient is in need of immediate medical care, that has to be given. So then it should not be, if the patient is in need of immediate medical care, then it cannot be denied in any circumstance.
And one more thing to add up, if such a patient, if any doctor is facing in anywhere, any private hospital, any government hospital, it's better to involve the investigation agencies. It's very much simple to inform to the nearby police station or the police chowki, which is inside that institute, that hospital. Definitely all emergency hospital has a police chowki. Okay, so you have to just it's very easy to do so that to the treating doctor, you can just say to the police station that such patient is there, it's very abusive or uncooperative to the treatment. If it's not cooperative, then how a doctor can proceed with the treatment? It can harm more. So better to inform to the police. If possible, with a reasonable force of the police, you can undergo the procedure. If not, just inform such case is there. We are referring to the higher center or wherever its treatment can be possible. But for after giving the first aid, that is important. So any further questions you have, you can ask on the live chat box. Any related to the medical issues or the law issues, okay, or whatever we have discussed in our week 1, week 2, week 3.
There is another question that has come.
Any questions you have, you can put it on the chat box.
Yeah, there is another question that has come with regard to voluntary non-fit injuria. The plaintiff with the knowledge of risk has voluntarily agreed to suffer harm. Would this apply to informed consent obtained for any medical procedure? That is the question. So the principle of voluntary non-fit injuria is a principle which is based on autonomy and voluntariness of a person to get into an activity. But of course, it has its limitations. So especially in case of medical research where a clinical trial is conducted or in similar situations, the plaintiff shall be compensated to the extent the plaintiff had no knowledge of the research activities. So up to some extent, the willingness shown by the patient will help in resolving the liability. But at the same time, plaintiff shall be compensated to the extent the plaintiff had no knowledge of the research activities. And also, there are also recent discussions which stress on giving full compensation on the ground of humanity.
Hopefully the answer is clear for you. If you still have doubt, you can put on the chat box. Yeah, one more question I have asked regarding the consent part, regarding the section 90 of IPC. So it is a consent that given person with an injury due to mistake of fact. So how to explain this? So in that scenario, what is the section 90 of IPC related to the consent? Okay. So if person is you can feel person is have no capacity to give a consent. So that can be the different scenarios. First and foremost is if person is unconscious or due to head injury can't able to speak, or maybe even pre-vegetative state, or it can be an intoxicated stage or alcoholic, means overall, or maybe in case of minor, okay, not attain the age of maturity. So in all these cases where the patient himself or herself not able to give a consent, so it's a duty of the doctor to take a consent from a legal guardian or the near relatives. But if in case of emergency, there is a need of first aid or sudden operation, definitely in a saying for the good faith and a benefit for the patient, immediately the doctor can rush for a particular first aid for a treatment and procedure in case of emergency. In that scenario, the consent will not be required in case of emergency. Otherwise, the informed consent is very much necessary. and you can inform to the near one relatives, but in case of emergency, you can proceed it immediately. And later on, and even after giving a first aid, if patient become conscious, definitely you have to inform to the patient that we are proceeding for this procedure. So everything should be documented properly, and then the doctor has done a like safe practice. So like that, you can proceed with the different scenarios coming during your routine practice.
Okay, there is another question that has come, which is related to RTI. If sometimes RTI applications are sent to hospitals, can they deny answering? If under the okay, so this is related to the Right to Information Act. So normally the information which is related to the confidential aspects, like related to the privacy of a patient, that has to be delayed, because medical information of a patient is considered as confidential information, which is part of the privacy of that person. So such information need not be divulged under the RTA Act. But however, administrative and regulatory information can be divulged under an RTA application. So the hospitals has to be very careful in giving medical information of specific patients, because this is related to the privacy of the patient, which is their constitutional right. So before giving out any information related to the medical record of a person, the consent of that person has to be taken, and without the consent, it cannot be given to any other person. So under the RTA anyway, there is an objection with regard to there is an exception with regard to giving of private information. So this information need not be divulged under the RTA also.
And also, if that particular patient belongs to any medical legal case, so definitely such information is very much confidential, and only that information can be shared with the investigation agencies. And if there is any written order through court, then only the copy of that particular treatment record can be shared with anyone. It should not be even shared with any defense lawyer, any advocate, anyone except the investigation agencies who have the right to look over that treatment records. So such things are really happening in a practical aspect. If any medical legal case is there, anyone will come, I'm the relative, please share the copy of treatment. But that should not be there. In all the medical records, even medical legal records of that particular patient, all should be confidential and should only be shared in case of written order by the court or the investigation agencies. This is under RTA Act. So another question being asked, if the patient has been counseled about the risk of a medical procedure and signs an informed consent for if that risk happens, are you saying that they are liable for compensation? So we have to just say that, like in informed consent, what happened, like we inform each and every step of that particular procedure about the risk and how the procedure will go through. But sometime the any mishap can happen or a new adverse event can happen in that particular procedure. So if that adverse event is related to a very severe damage and even to death, then that doctor will be held liable or under criminal negligence. But if any everything being documented properly, explain all the risk and the procedure of that particular treatment, then the compensation will not be granted if any mishap happened. The doctor has followed the balance principle, that is an educate care and the skill of that particular procedure, and it has been already informed through informed consent that there can be a risk or chances of the risk which are being mentioned in the informed consent related to this procedure. But if new adverse event have happened, then there can be chances of providing any compensation under any consumer redressal commission if the case is being filed under that consumer court regarding that particular negligence. But if doctor or treating doctor has followed each and every step of documentation and the Boland principle that the procedure being done as an educate, skill and care, then it will be very difficult to give a compensation. The damage has happened to the patient. But if there is any lacuna, towards the treating doctor side? Definitely the damages. We say the term legal word damages, that is a compensation given, or whatever the consumer court, consumer forum says, the doctor or treating doctor has to follow it.
There is one question: after completion of the course, can I practice medical law? So, of course, this course will give you an overview of various aspects of medical law. It covers both the ethical aspects and legal aspects related to medical profession. So, if you are already enrolled as an advocate, or if once you enroll as an advocate, you can, of course, practice in the area of medical law. But if you are not an advocate, then you cannot practice. But anyway, this course will give you an overview of various issues related to medical law.
So regarding the practice, as you are telling about the medical law, so what kind of practice you are talking about? Are you talking about the medical legal consultancy? So, but you should have a degree which is to be recognized under some council. So, like as MBBS degree, you should have an degree should be recognized under Medical Council of India, now as National Medical Commission, or your as a law background. So you should have LLB, LLM under Bar Council should be recognized. So, but with an additional knowledge of medical law, like or medical law and ethics, you can easily help to interlink between the medical cases with the legal cases or what are the issue faced. So all together, you can combine it and can helpful in your routine clinical practice as well as the legal practice. So, but only like after 12th, you are telling about medical law, studying this course, or after just a graduation of BA, BCom, not related with the medical and law, then it will be very difficult for you to even practice. So better to have a basic degree related to the medical or the law, and then intermingling our medical law course, then it can be very helpful to further practice or further enhance your knowledge or enrich your knowledge through this course. It will be very helpful for your routine practice. Now, one has asked about the time frame of keeping the medical records. So it is very much clear that it is very much good enough for a treating doctor or the corporate hospital or the government hospital to keep the records to till like many years. But it is being guidance has been mentioned in OPD cases, minimum should be 3 years. On IPD cases, it's 10 years. And whatever the being medical legal cases, it should be kept till that case get disposed of. And but always the recommendation is a safer recommendation. Keep it as much as possible till how long. But the standard guidelines is 3, 10, and no limit for medical legal cases.
There is one question regarding uploading of slides in PDF format. So please note that we already uploaded the slides in PDF format. I hope you all have received the slides.
Still, we will ask our technical team, like one has asked to take a printout. If you have faced any problem, you can put a mail to the technical team and write in the discussion forum, whatever the problems you are facing regarding the PDF or the materials related to our course, we will rectify it. Thank you.
Okay. All the slides we are uploading in PDF format, but if you didn't receive it, in case there is any difficulty in accessing it, please put in the discussion forum. We'll address this. We'll also check with the technical team what is the issue.
So, like somebody has asked about the refusal or the elective cases. So, it is very much clear that, see, if like in emergency cases, definitely the first aid is very important. Okay. But if it is a routine procedure, elective case, the person has come up and the doctor has explained about the procedure. So, it is like there are the many terms. Okay. Now, yes, the term is the refusal for particular treatment, or even LAMA, that is a leave against medical advice. So the doctor's duty is to explain each and every step of that procedure. If or the various options alternative like the surgery, or even surgery also open or the laparoscopic or chemotherapy or radiation therapy, anything. So, but it's the right of a patient to choose what treatment, but the doctor's duty is to counsel it. So these are the risks and benefits of particular procedure. These are the side effects of that particular procedure. Now, what right you like? It's a right of the patient also to select which type of treatment or even refusal to that particular treatment, but it should be documented. That is foremost. The doctor should take a documentation that such has been explained each and everything. What are the risks involved if the person refuses for following that particular treatment, and it is being referred to the higher center. It should be that, okay, you are refusing for the treatment from my part, please being referred to the higher center. You can suggest that this is the further specialist doctor, you can visit it, take a second opinion. So it is completely right of the patient to choose what treatment he want to take for him or herself. So that it should be documented as a refusal or leave against medical advice.
I think we have answered all the questions. But if you have any further questions, you can please put in the chat box. We'll respond to it now.
So, like somebody has asked about the lecture on the quantification on compensation. So, I think you are asking about that how the damages being calculated by the consumer forum in a medical negligence cases. So, it is very much subjective to case by case basis. So, it is very much clear that the person who is being affected, it all depend on his or profession or how long that case has been there. So after being filed to the consumer forum, so it's being subjective to subjective. So it's being calculated on the basis of that profession of that particular patient and how much they have prolonged till the judgment has come up. So, and what all the emotions or related to that profession. Okay, there are a lot of other factors also being counted. So like that, the damages, the word is the damages. You should always use the word damages. Damage is the any mishap happened to the patient, and damages received is the compensation amount received or given by the consumer forum, that doctor or the treating doctor or the any hospital involved. So that is a word is damages. So it's a many factors are involved to calculate the damages involved in any case of negligence. Anything else you want to ask?
Another question.
So I think you are asking about repeated about the section 90. It's not being cleared. So it is about the consent, like being given by the any minor or any insane person, or means under fear or the misconception. Like you have to explain clearly to the particular patient or a person that what is being happened. So mistake of fact, I think the person is asking. So you have to explain clearly that what all the procedure being there. If you are thinking that the particular person has not a capacity to understand what all you are telling in that particular maybe native language being required or whatever, so you can call any relative and explain. And if it is being there that the consent is being taken under fear or misconception, so that consent is not valid. So that is being explained as section 90 of IPC. So that's the consent taken under fear or many misconception, mistake of fact. So you have to explain the completely. If it's not being explained, it's being clear that the person is not able to understand and you have proceeded it simply. So then that consent is not valid and you will be held liable. You means the treating doctor, he will be held liable of that particular act done on that particular person. So that concern will not be valid. So that is a thing under section 90 of IPC. The concern is taken under fear or misconception.
Okay, so that it means that it has to be the conditions of the patient has to be properly explained, and then only a valid consent can be taken. So if there is a mistake or misinformation being given to the patient, then the consent given by the patient or his near relative won't be considered as valid. That is the effect of section 90. Another question that has come is, would it be possible to see court proceedings? Are there videos? So there is no specific video of medical legal cases available, but anyways, High Court and Supreme Court, some of the hearings you can see through YouTube. There are online videos available that you can refer to. But anyway, specific cases of medical legal aspect, I have not seen any such video recording available in public.
I can just tell my own practical experience when I have been called as summoned. So how it court proceedings happen. So first and foremost is the respect to the court. So you should be well dressed, first of all. Okay, as you are the doctor, so you should wear your doctor's coat. It's not necessary to take your stethoscope, but it should have a very legally or properly dressed or formal dress with your doctor's coat. And then as you enter the court, you have to respect to the judge, and then you can proceed, okay, after taking a oath. So whatever being question asked, so it's a first of all foremost is the oath, after respecting to the judge. After oath, it will be started as a examination in chief by the PP, so public prosecutor. So he will tell what all the incident happened. You can tell that these were the I have recorded, I have found out these are the findings, and so this is my records, and that all records you have to explain it in a native language. You can try your best to use the English or the native language which you know it. Okay, better is always the English, it's uniformly accepted, or if doesn't able to find it out, then native language is also fine. And then it starts in the defense lawyer. If any the cross examination, the cross questions will ask, that's a leading question, mostly the yes or no answer. Okay, so you have to explain, so whatever the doubts the defense lawyer has, and then later on again the re-examination can also be there by the public prosecutor to rectify any doubts being come. And in between, if any respected judge want to ask any question, so judge can ask at any point of time. So like these are the court proceedings. So after it's being done, definitely is foremost another important is the attendance part. As you have attended the court, and even if you are not attended the court also, or the proceedings not happen, it's very much foremost is to give the attendance to the public prosecutor that you have come up for the someone being called. Okay, so these are the very common court proceedings. Definitely, as Professor Narendra has told, you can go through the High Court and the Supreme Court YouTube recordings. So that can be having the different scenarios. As I have visited up to the session court, so mostly these are the main procedures, legal procedure. That's the examination in chief, cross-examination, re-examination, or the any judge, respected judge want to ask any question. So these are the procedures.
Okay. So there is another question that has come, that is malpractices in medical profession. Can you suggest some landmark judgments presided by Honorable Supreme Court, and how to prove medical negligence from the point of view of a patient? So with regard to the Supreme Court judgments, we have mentioned some of the judgments in our lectures. But anyway, additional to that, we will upload one document with all the latest cases and the explanation of the cases in the chat box, so that you will be able to understand. Because if I give some names during this session, you will not be able to follow properly. So for that, we will give some explanation. And what has to be proved in a medical negligence case is firstly the legal duty of care. So there has to be a legal duty of care, and that duty should be towards the plaintiff. And there has been a breach of such duty by the defendant, and because of that breach of duty, damage has been caused to the plaintiff. This has to be proved in a medical negligence case. So when you approach from the perspective of a patient, first you have to prove that the doctor owed a duty of care to you, and secondly, the doctor has failed to perform that duty which is expected as part of the medical profession. And now, because of that breach of duty, there is some damage caused to the plaintiff. So all this has to be quantified, and based on that, a claim has to be filed. Appropriate case has to be filed in the forum, and based on which the compensation will be decided by the court. And there is another question with regard to basic understanding of vocabulary of this medical law course. Is there a book to refer? So one you can refer is to a medical legal dictionary. There are some dictionaries available. We'll suggest some dictionaries in the chat box. And then additionally, we can
It's
also
Modi's textbook of medical jurisprudence. That also you can go through. It's the latest edition, it's 25th edition, has come up with the LexisNexis publishers. So that's also very good textbook, which has an interlinkage with the both medical and the law. So Modi's textbook is very good. You can go through that. Okay, and another question being asked: a minor girl underwent an MTP. That's a mid termination of the pregnancy. So it's a minor girl. So she undergoes a pregnancy. So as per the POXO Act, so it's a less than 18 years. That's a minor. So you have to understand. So this thing has happened as an it's being reported as a sexual assault has happened to her. So it's a completely as medical legal case. So we have to inform each and every step to the police or investigation agencies. So this patient has come up, okay, even with an concern which is happening. So with the age of 12 to 18, it's an period, but it's a minor as per the POXO Act. So definitely we have to, it's a medical legal case, we have to inform to the police and proceed the, but MTP is being done. It's not that not necessary, but we have to inform to the investigation agencies and follow the POXO Act and the MTP Act and proceed it without revealing the identity. Should not reveal the identity of the victim. So I'm just informing you, we will also be taking a second live session. If maybe we have missed few questions, you can put it on the discussion forum. Also, you can at the end of our course of the week 8, so we will be conducting another live session, definitely around mid-April. So you can come up with a question, and I will just request that you put it your questions on the discussion forum also. And definitely, if not possible, you can ask on a live sessions. Okay. So still we are here. If still you have any doubt or if you missed it, you please retype it and we'll try to rectify. Still any missed, you please immediately put it today itself on a discussion forum. So these are the doubts. Okay. And hopefully we have answered most of you. And if still you have doubt, okay, you can repeat your questions, no issues.
if we have not answered any question, please repeat the question. There is some question as to the validity of the course certificate. NPTEL course certificate is valid. You can refer to the NPTEL website for this. But are you asking whether the certificate is valid for practicing law? No, the certificate is not valid for practicing law. This is an additional qualification. So for practicing law, you should have to complete the LLB degree from a recognized university in a full-time mode. So there is no part-time law courses available. So it has to be in a full-time law course, which has to be done from a university which is recognized by Bar Council of India. So that is mandatory for enrolling as an advocate and practice in the field of medical law. But in case if you are a student, you want to get additional credits for your course, then the certificate is valid. So one candidate is asking, is second week assignment, can I still opt for certificate examination? So please write to us. We will forward it to the technical team of NPTEL. They will be able to advise you on this.
But we will suggest that please don't miss further assignments. You have to complete your all assignments to participate in the examination.
I think we have covered all the questions, but if there is any further question, you can put in the chat box. We will respond to it now. And later also, if you have any doubts, please feel free to mention in the discussion forum or write to us. We will be very happy to respond to your questions.
And go through all our video lectures, and soon the transcript will also be available for you for further understanding. Okay, and you can give the feedbacks related to it.
So if there is no further question, then we can close the session.
Yes.
So thank you everyone for attending the session. I hope you are all enjoying the course. This course is intended to cater to the needs of people who are from the medical profession, lawyers, students. We understand that the participants are also from diverse field. We realize that from your questions. So I hope we were able to answer most of your queries. Additionally, if you have any queries, please, as I said earlier, please feel free to write to us or put in the discussion forum. We'll be responding to all your doubts. And we have promised to upload some documents that we will do very soon in the discussion forum. Please refer to those documents as well. So now we are completing the first 4 weeks of the course. There are another 4 weeks remaining, which I hope will be very interesting for you, in which we will be covering the advanced areas of medical legal profession. So please listen to all the video lectures and do the assignments.
Thank you.
Okay.